Hello. On this video, I would like to spend a few moments discussing some of the differences and similarities between civil law and criminal law in the United States. The text that we're using for this class, Legal Environment, brushes over some of the differences in particular in Chapter 7, but it does so fairly quickly. So I'd like to highlight those a little bit more and to help to show that in addition to those differences, there are also similarities that we see between the two, and I'd like to talk about those first. Now, some of the similarities between civil and criminal law and the way it is practiced in the United States are that they all take place in an adversarial process, that there are few trials associated with them, and that they are generally shaped by the rules of the state. There might be others, but these strike me as three of the most important. Let me talk about the adversarial process for a moment. In the United States, in our court system, conflicts are resolved by two opposing parties, each arguing their cases as zealously as possible before a neutral third party who makes a decision. There are two things that I think are important to note about this. Number one, it clearly requires that both parties want a different outcome so that they can meet the second requirement here, and that is that if I have a different view of a set of circumstances in a conflict then does in fact the other party, we both have a vested interest in bringing forth as much material as possible to make our point clearly, and we both bring forth as much material as possible, and then we lay it before a neutral third party who in fact decides as much as we can in a court of law what the truth of the matter was that occurred in the conflict at hand. So if I have a conflict with my landlord and I say that I did not cause damage to the apartment that he says I caused, we both have a vested interest in providing as much evidence as we can for our respective positions, and then we allow a neutral third party to make the decision about what the truth of the matter is. This is somewhat different from what you might see in an inquisitorial system that is practiced by some countries, in which the judge plays a much more proactive role in ferreting out information that is important to determining conflicts. Now, we'll see in a moment that many cases do not actually go through the full-blown adversarial process in a trial, but that doesn't mean that the adversarial process does not influence those cases. It is often said that when bargaining or negotiation occurs, that results in some sort of a resolution to a conflict before the actual trial, that this still happens within the shadow of the courthouse, meaning that the possibility of going through an adversarial process actually shapes what in fact happens in that bargaining and negotiating process in settling a conflict. So both of these kinds of cases in the United States, both civil cases and criminal cases, take place in an adversarial process. It is also important to remember that most cases are resolved before trial. In the criminal side, this data is pretty clear. The hyperlink there takes you to a Department of Justice report that notes that in both federal and in state criminal cases, in 90 to 95% of the time, fairly consistently, trials do not occur, but that in fact plea bargaining occurs, so that the prosecution will offer either a reduced sentence or a reduced criminal charge in return for the defendant pleading guilty. There are a variety of arguments, pros and cons, about the plea bargaining process. We won't get into them here. There's a little bit of that in the Department of Justice study if you would like to look at that when this PowerPoint is in fact posted on Blackboard. On the civil side, the data is a little less clear. We often hear the figure 90% thrown around, saying that 90% of the time civil cases are resolved before they go to trial. It might be fairer to say that in 10% trials occur. That doesn't mean that they're settled. There are a variety of other ways in which cases are resolved short of settling. It also depends on what kind of civil cases we're looking at and how you define settlement. The first hyperlink there, for anybody who's interested, I encourage you to look at. It is a study done by some Cornell law professors about the question of settlement. How do we define that? What do we mean by that? And the wide array of civil cases that occur. So that in federal courts, the courts they study for this report, they find that the largest percentage actually end up being employment discrimination cases, and not your traditional civil cases that we think of when one person sues another perhaps for damages or for wrongful action. And the numbers they find range anywhere from 23 to 88% settlement. So the 90% number is not so clear. Similarly, in state cases, very few actually go to trial, 3 to 5% perhaps. Many are decided, though, by default. Others are settled. Only a small percentage are actually adjudicated. This report takes you to a National Conference of State Courts study that talks about the kinds of cases that are seen as civil cases in courts in the United States. It's a pretty interesting look at that for those of you who might be interested. But the reality is that in both criminal and civil cases, fewer cases actually go through a full trial than we might expect. And last but not least, and what might seem like a no-brainer, both civil and criminal cases take place within rules set by the government. First, both courts, civil courts and criminal courts, operate under rules, and those rules are established by statute for both civil and criminal proceedings in both state and federal courts. So what can happen in the process by which things happen in the courtroom are established by the government. Then, of course, obviously, criminal laws, if you are charged with violating a crime, those criminal laws are established by statute, either by states or by the federal government, right? And in civil cases, this doesn't seem quite as evident to us, but it is in fact true that when we apply a standard like negligence in a tort case, what is negligence is defined in statutes, and then it is refined by decisions of appellate courts. So the rules by which conflicts are processed, and the actual law that is applied in all those instances is established by the government, either of the state, if it's a state conflict, or by the federal government, if it's a U.S. conflict. So those three things, the adversarial process, the fact that many cases are resolved before going to trial, and that all of the conflict resolution in courts takes place within rules set by the government, are similar in civil and criminal cases. There are, however, as your text notes, some differences, and I would like to point those out for a moment. Number one are the parties to the case, right? In a criminal case, it is the government that brings the case against somebody for violation of laws, and those laws are enacted to protect society, not just one individual, and that's why either the district attorney in a state or the U.S. attorney on the federal level is the one who brings the case. I don't bring a case against somebody because they assaulted me. The district attorney of my county does, because he is not only protecting me, but he's protecting all the citizens of the county in making sure that people are held to the certain kind of behavior that we expect out of citizens in our community. The defendant, of course, is then the one who's being brought to court and being charged with the crime. In a civil case, there are usually private individuals who are involved, although the government can occasionally. I'll talk about that in a moment. Most of the time it is one individual or company, corporation, a wronged party who will bring a case against another party for harm that they have suffered. In the classic kind of automobile case, I might sue somebody who I think was wrong in their driving, who hit me, and I therefore suffered damage, both loss of time at work, medical damage, and I'm asking that they have to pay me for that because of their negligence. This could also be breach of contract cases. This could be wrongful termination cases. There's a variety of cases that we consider civil cases, but all of those are usually one party, individual, company, corporation, against another party, individual, corporation, not often the government. You can have the government involved, for instance, if somebody is contracting with the government and it's a case, but in that case it is a civil case, not a criminal case. But most of the time, parties to the cases are the government versus an individual in criminal, and individuals versus each other in a civil case. Most of you probably know that the burden of proof also varies, or at least you have heard of the kind of burden of proof that is required in a criminal case, and that is to be found guilty of a crime, the government must provide proof beyond a reasonable doubt. And the burden of proof is always on the one bringing the case, so the burden of proof is on the government. Why is it so high in a criminal case? Well, in part because the government has a great degree of resources at its disposal to make its case, and so we want to make sure that it has to do its job. Perhaps more importantly is that if in fact the government succeeds in in proving you guilty of a criminal charge, that the penalty can be pretty serious, and we'll talk about that in a moment. On the civil side, the burden that is usually applied is a preponderance of the evidence, or more likely than not, that in my car accident case against my neighbor, that the way in which I describe the accident is the way that it occurred and that they are in fact negligent. That's what I would have to prove, more likely than not. There are a few kinds of civil cases where we think that the potential harm caused by a remedy is so great that we really want to be careful. So we use a burden someplace in between beyond a reasonable doubt and preponderance of the evidence, and that is called clear and convincing. The case that I can think of where this might happen most often is when in fact the state is looking to remove a child from the home, and we want to be sure the government gets it right, and so we might establish a higher standard for a burden of proof in a case like that. The penalty is also very different between a criminal and a civil case. In a criminal case, as you know, if one is found guilty of a crime, one could be fined, but more likely one will find some loss of liberty in some way, up to and including prison, or in the most serious of cases, loss of life, if in fact the death penalty is imposed for the crime that one has committed. Very serious ramifications, loss of liberty or loss of life, and that is in fact why we put the burden so high on the government in some instances, right? On the other hand, in a civil case, if one is found liable or otherwise at fault, the penalty could include damages, and that can be either compensatory or punitive. Compensatory meaning literally paying me back for whatever I suffered because of your wrongdoing. Punitive is applied by a jury in some instances to make sure that an individual or a company does not continue to repeat this wrongdoing with other people, to make it expensive enough for them that they will want to change their behavior, right? So that would be in a tort case. Or you might get an equitable remedy, an order by the court to not take an action, to fulfill a contractual obligation, for instance, if it's a contract claim, to rehire somebody if it was a wrongful termination case, okay? But never a loss of liberty or life, which is solely in the domain of the government to be able to take on. And last but not least, the difference can be seen in the verdicts. In a criminal case, with a few exceptions in a few jurisdictions, to find somebody guilty of committing a crime requires the decision of a unanimous jury, usually a jury composed of 12 citizens. In a civil case, some variation between jurisdictions, but in cases involving a jury, it only usually requires 3/4 of a majority to determine liability. So if it's a 6-member jury or a 12-member jury, only 3/4 in order to find that somebody's in fact liable. Again, the consequences of being found liable in a civil case are not quite as serious as those of being found guilty in a criminal case, and therefore the standards we set are somewhat different. Those are some of the similarities and differences between criminal law and civil law in the United States. The bottom line is both affect business and industry in the U.S. The goal, I think, for both individuals as well as for companies is to avoid the first, to avoid criminal law in all cases, and to use the second, the civil law, in ways that shape the best possible environment for your company. Thanks for your attention.